do vacant and take longer to recover. It'll actually recover quite quicker if you disturb it. You know, and then also, you know, you got these bare soils where it's burning hot and et cetera, and they wouldn't be better off to go ahead and plant some grasses in there to help stabilize that soil for some of the erosion factors.
Yeah, I mean, those are all things that are good points when we do the analysis and paint the picture between taking no action and what we propose. You know, we'd want to hear those comments and consider that in our analysis for sure.
I just had one question, and reading, I'm looking at the ballfire one, but I think there was similar information in the Ira one as well. On page 11, you talk about air quality. You talk about pest abatement, how you can bring in trucks to keep water, to kind of keep the air quality manageable and so forth. But there's no discussion as it relates to air quality in terms of the impact of the burn piles. And then on page 7 and 13 in particular, you have, and there's scattered throughout the document as a whole, you talk about how you're going to pile mechanically or by hand and how these piles are going to be burned. And there's no, I don't see any kind of correlation with, I mean, obviously that's how you're going to dispose of the stuff that you can't haul away because it's too, it's not big enough to haul away. I mean, you can mulch up some of it and haul it to the cogen plants, but there's always the stuff that's left over, really the trash. And that's an acceptable format. But I know that we've had in years past problems with the different entities coordinating themselves through their resources control board folks in terms of if everybody sets off their piles at once, you can create a pretty thick smoke layer. And especially when it comes to the prime time for recreation, which is supposed to be the replacement economy, it doesn't do us a lot of good to recreate or attract people to come here and recreate in our backyard if we choke them out by burning the piles in kind of an indiscriminate fashion. So I didn't see any discussion about how that was going to be managed in terms of how those burn piles would be eliminated. So I think that would be really helpful to have as part of the discussion.
Sure.
Because I know at one point we had to intervene as a board because we had Lassen Parking and they were doing their thing. Lassen National had its thing going. We had some private folks on the private force trying to take care of some of the similar kind of things. And they weren't talking to each other. The Plumas was burning stuff, and then we had other, and the air body is huge. So stuff that's happening down in the valley and on the west side was drifting over here and mixing with the stuff we were trying to do on the east side. So all that needs to be kept in mind.
Okay, fair enough.
Any more questions?
One other thing I'd like to see when we talk about the reforestation, you talk about planting up to 300 trees an acre. I'd like to see some long-term, after 5 years, you're going to go whittle it down to so much, and after 15 years, whittle it down, because otherwise, then you just end up with a complete monoculture, which I've seen in other burned areas where there's no understory whatsoever. If the fire does get started there, you don't keep it thinned out. You've lost everything.
Sure. So paint kind of a picture of how we're going to create some diversity and not simply an even age plantation in those areas that we reforest.
Well, but also keep spacing within the reforest, that you're not going to have another fire come in there and smoke everything again.
Yeah. So highlight that the pre-commercial thinning. That would be all
Yeah.
Sure. Okay, fair enough.
Any more questions? Seeing none?
So the next one is the designation of the over snow vehicle use plan. Essentially, we have a current system of over snow vehicle use, which is primarily snowmobiles, of course. We were challenged in a recent lawsuit, and part of that settlement was to go ahead and do the environmental impact statement for 5 different national forests. So there's 5 EISs that will be prepared. And so where we are in the process now is it's open for public scoping through February 19th. Proposed decision is October of 2016. And you have the scoping documents that were sent to the board that I think create a pretty good picture of where we are now and what's being proposed, which is very, very similar. And so, just to highlight, I know access is probably a concern of folks. Right now, essentially 85% of the Lassen National Forest is open to over snow vehicle use. There would be a slight change in that proposal would drop to 82.4% if my arithmetic was correct this morning. So, a couple percent drop, and that's the proposal, of course. That's not a final decision. That's a proposal. We expect, good comments, and we expect maybe even an alternative that might come forward during that. So, if you do have concerns from folks that are there going to be large decreases in access, no one is proposing that. What is proposed right now shows a slight decrease when it comes to acreage. The actual miles of designated routes are proposed to be the same at this point. But, we're obviously in the public scoping period, and there's plenty of opportunity to accept comments and consider those in our analysis.
Jimmy, have a comment?
Yeah, last November at the county's conference in Anaheim, I had a chance to sit in on a session that was put together by one of the county supervisors from Amador County, and was dealing with this specific topic, in which he'd gone to some sort of a meeting, I guess was held at the regional office just before that, so that'd be sometime in probably early November, and in which he was kind of concerned, and what he was sharing with the group as a whole, that the five forests involved, there's roughly 1,000 miles, I guess, of trails and stuff. So the El Dorado and the Lassen, I think, were the two biggest. There was some stuff in Tahoe, and I can't remember the other two forests that were part of the mix. But in the bigger picture of it, what's happening here on the Lassen accounted for about 45, almost 50% of the, you might say, the general public access to the public lands for this kind of recreation. And the concern that he was expressing, and he felt that this process was really designed kind of much like the travel management type program, designed to try to curtail access to public lands rather than, assuring that that was going to be kept intact or preserved. So are you suggesting that here on the Lassen that we're going to be more like status quo, or are we going to be looking at some curtailment in terms of recreation opportunity with this process?
Well, with the proposed action that we have out for comment now, as far as miles of designated routes, that would remain the same. And there's a good chart in here that compares the two. And actual acres open is showing a slight decrease, a little over 2%. So there is a slight decrease being proposed. But, if the board wants to comment on that proposal, then absolutely.
Yeah, okay. I think the decrease, that part of it is minimal because of, it might be to do to some habitat thing that you're zeroing in and wanting to protect. I know in two of those forests, I think the El Dorado was the biggest one, they were looking at some major curtailment of just the overall miles that would be available. So
yeah, that's not the case here.
and I think that's the important thing that we need to reinforce. I think the position the board should look at doing it. February 19th is the deadline. So you might want to get Richard on the next agenda, correspondence or something in which we emphasize the importance of maintaining that.
As I reported earlier, the coordination committee council met last night, and we don't think that the proposed action was that the Forest Service worked with the coordination council to the full extent they should have, and they are going to be asking this board to ask for a 30-day extension on your public comment.
Sure, and you're welcome to ask for that, as you see fit.
Yeah. But I think, if that's what they want to do, I think we can obviously do that, but I think at some point we need to emphasize that position that we have as a county is to try to maintain the accessibility and the miles. And from the report that you're giving, it sounds like that's where the Lassen is going, because that's not necessarily true in some of the other forests, and that was the concern that was raised at the meeting in Anaheim.
Okay, any more questions? Anything?
I had one other question. I'd like to go back to the bonfire salvage and restoration. One of the deals here under riparian conservation areas, soils must be dry at 10 inches deep before heavy equipment can be operated. Can you elaborate on, is that bone dry, or what percent of moisture are you talking about? It's on page 15. Very top.
I would have to check and see. I don't know right now.
I mean, a lot of times when these numbers are going to be attainable.
Sure.
Bone dry at 10 inches.
Right, exactly. Yeah, I understand your points. How dry is dry. Yeah. Okay, fair enough.
They're just trying to keep you stuck.
Good. Any more questions? Thank you for your report.
All right.
Okay.
Have a good day.
We'll be glad to see you again.
All right.
Okay, we're going to go on to H10, marijuana. Jerry's the only one here who wants to. Jerry's been working all day for
This one's going to take a little while, Mr. Chairman.
I know, and we got a meeting at 1:30, so we're gonna have to continue on and get this through.
Let me expedite then. Mr. Chairman, members of the board, good morning. This issue, just to kind of recap quickly how we got here, came to us as a result of conditions which existed in one of our subcommunities, perhaps more than one of our subcommunities here. And Mr. Pyle asked the matter be scheduled for a study session in November. We held that study session at the Veterans Hall and received a considerable amount of testimony from individuals on all sides of the issue. It came back to the board shortly in December with a request for information from myself, and been doing a lot of research on this issue. It's not a simple issue. What you have before you today is essentially a draft, if you will. But I want to say that it's a draft with, it's really intended to be just an introduction to you, a taste of the structure, if you will, as to what I think may come from this board in final form in the future. And so, I'm going to tell you straight out, this ordinance that's here for this draft ordinance, this is, I didn't write this. Well, certainly I included some provisions, but for the most part, this draft ordinance is a reiteration, if you will, of an ordinance that has been tested in court and sustained. And it comes originally from Tehama County. We know that Tehama County Council has been at the forefront of the, let's call it land use ordinances and nuisance ordinances associated with the cultivation of marijuana. And in fact, Tehama County was involved in litigation for that purpose and essentially won the day. From that ordinance out of Tehama County, others have modeled their own. Of course, they have substituted their own judgments in terms of quantity of plants and setback requirements and categorical exclusions as to where marijuana might be cultivated in relation to like schools or churches or the like. But by and large, the structure of the ordinance is the same in a number of counties, and that's what this particular ordinance models. It essentially is a model made after the Tehama County ordinance. This really is closer to the Sierra County ordinance, and so that's what I wanted to introduce to you today. Now, there was some consideration about the approach to preventing some of the issues that were identified in the study section. And some folks were complaining about, the smells, the traffic, the pit bull dogs, the whatever the other issues were, and I don't have a laundry list of them, but there were a number of issues that were identified that speak to nuisance issues. And that's important because this body has the legal authority under its police power to regulate public nuisances that occur in the county. If we were to be making a zoning law, we would have to consider the general plan, and we would have to be involving the planning commission, perhaps, but that's not the direction. We didn't approach it from a zoning perspective. We approached it from a public nuisance perspective. And that's consistent with what Tehama did, what a number of the other counties that have followed suit have as well. And so consequently, you have, one other point I wanted to make was initially, when we agendized this issue, after Mr. Pyle asked it be brought up, it was agendized in the context of a potential amendment to Ordinance 575. And that was the one that was adopted by this board in, I want to say 2011 or 12, I don't recall the year, related to no dispensaries. November
2010.
Thank you. And I'm switching up a little bit on you here. I am indicating to you that I don't think amendment is the appropriate vehicle. I think the passage of a new ordinance that will supplement and or augment 575. 575 stands on its own and will be just fine. And if, or in whatever final form this thing takes, the two can work together just fine. I wanted to mention that. So really, the structure of this draft, I view it, there's three things to really talk about in terms of the structure of the draft. One is really more, I don't want to call it window dressing because it's important to identify the problems that have led to the formulation of an ordinance, and that is the findings and purpose provision, which starts on page 1 of the draft. And that does, I think, do a fair job of identifying the problem over time with the passage of 215 and then Senate Bill 420 and then the problems we've seen in our communities with marijuana essentially being cultivated in unregulated numbers to the point where people who just want to enjoy the peace and quiet of the property, and not have to smell it or see the traffic or be approached by the pit bulls or whatever the other sundry issues are. That's dealt with in the findings and purpose. The second point, for purposes of the draft ordinance, is the conditions of cultivation, and that's found at 1.040, starting on page 4. I'm not going to go through it specifically unless there's questions, but conditions for cultivation, that's the meat of it. We'll get to that in just a second, but that's where you can grow and where you can't grow, no matter how many recommendations you have or however much the law permits you to cultivate, where you can't grow, like in proximity to churches or schools or the like. So that would be set forth in conditions of cultivation, and everything thereafter in the draft ordinance would be under what I loosely refer to as the third category is enforcement. And that's a complicated issue. It is a complicated issue. And so, I mentioned to you, I think from the very beginning when we had a study session, whatever we do, whatever ordinance you pass, you adopt, that it have an enforcement component to it that has credibility and is effective. And that is what's found in all of the provisions after the conditions of cultivation. And so, I'll get back to conditions of cultivation in a minute, but on the enforcement front, there's provisions in this draft ordinance that relate to administrative fines being imposed. Okay, there's provisions which relate to civil action being instituted. There are provisions, there is a provision which essentially creates it as a misdemeanor crime, which you're empowered to do. You're empowered to create it as a crime. Suffice to say, in all three of those particular enforcement mechanisms, there are also, because we're obliged to afford structure for due process. If you're administratively facing, as a cultivator of marijuana, a fine because it's perceived or alleged that you're violating the county ordinance related to cultivation, you have a due process right, and that's built into this ordinance, and that's important. There's notice and hearing obligations, and so we can't willy-nilly create a scenario where we find someone and they don't have, it's just not American, first of all, but it's certainly against constitutional and statutory law. And then there's the civil action. That empowers the county council to go after an injunction if it's a repeat issue. And that we've seen in other contexts like abatements, like we saw one in Westwood on a house that had burned. We saw, we've seen a couple, I can't think of them right now, but Planning and Building Services has brought forward other abatements. It would go generally speaking, the same way. Could go the same way. Lastly, the criminal component to it is, again, misdemeanor. The due process there is a person accused of a misdemeanor has a right to trial by jury in a court of law. That would be something that the district attorney would have the authority to choose to pursue or not. The point is about the enforcement component is there's flexibility. No one provision is preferred over the other. It could be pursued administratively. It could be pursued civilly in a court of law. It could be pursued criminally, or a combination of those. And so, again, the enforcement section is complicated. It is essentially modeled after what comes out of Tehama and Sierra and some others. But that takes me to the conditions component, conditions of cultivation. A couple different ways to approach that. We could incorporate into an ordinance regulating the cultivation of marijuana. We could approach it from the standpoint of, look, you can pretty much cultivate everywhere you want except for these limited and enumerated ways. You could define it that way, and I guess that might be viewed as a kind of permissive definition, as compared to a negative definition, or for lack of a better way of putting it, by saying, look, you can't cultivate marijuana at all unless you do it this way. It's that latter way that has, at least at this point, been chosen, because we believe that that provides you, as the police power authority with the greatest control over the issue, to deal with the perceived nuisances that were complained about, essentially. And so let's talk about those conditions of cultivation for just a moment at 1.040, starting on page 4. There's a couple different kinds of, remember I said this is really the meat of it, okay? I expect this is going to change, and it may change dramatically. I am not married to this recommendation. This is essentially, these conditions of cultivation are what came out of Sierra County, and I'm just offering it to you for a taste of the structure of it, not to endorse the value judgments that have been placed behind these particular provisions, all right? I'm just trying to introduce you to the structure of it. There are categorical exclusions which say, and you can see the categorical exclusion that I'm referring to in paren C to .040 on page 4. And it says the cultivation of marijuana in any amount or quantity outdoors or upon any premises located within however many feet you decide of a school is hereby. So it doesn't matter how many recommendations you have. It doesn't matter at all about that. You're essentially given the opportunity to establish no-grow zones. And you are given the ability to decide whether it's schools, youth facilities. You can define that in the manner that you choose. Now, of course, there is some bit of a limitation, and that limitation is that whatever sites you identify as no-grow zones and a distance from them should be reasonably related to nuisances that could exist. You can't just say they're not going to allow you to grow near any house in Lassen County. Because that would ostensibly mean that no growing period. So there should be some reasonable relation to that. That's the categorical exemption. You'll see under paren 1 and paren 2 there's some language there, excuse me, some language there about how to measure distance, whatever that distance is that you establish. The Tehama ordinance, I think it was, 100 feet from a school. The Tehama ordinance was 1,000. In the city of Susanville, which you asked me to look at, I think started at 1,000, but it's been modified to 500. So there are value judgments which must go into that as well. Now, understand that what occurs in the city may be different than what occurs in the county based on simple density. But maybe that analysis isn't true if you compare the city of Susanville to the township of Westwood. There's a lot of density in Westwood. In fact,
Lake Forest.
or Lake Forest, precisely. So,
Thought that comes to mind, are we gonna marry our ordinance with the city?
that's one discussion point, okay? So that's a categorical exemption, all right, as compared to, say, for example, A. A is basically we're going to allow cultivation, but we're going to limit it to a certain number of plants per either. No. Well, yes, it does get to that, but individual cultivator or their primary care authorized
Card giver.
card holder, thank you. Authorized patient, I apologize, I was searching for the words. Authorized patient or their primary caregiver. And then there's a limitation in 3 that, and this is very important because this is where the issues really arise. There are many folks, in fact, we heard from them at the study session that say they need this many plants to get them through the year. I remember Mr. Hines, very colorful, and I enjoyed his testimony.
Yeah, 10 plants, and he smoked a lot.
He must smoke a lot of pot. I enjoy hearing from him. Then he went off on the UN thing.
He couldn't understand the 99 plant rule that everybody else was working on.
Well,
And up to and including 575, and if you look at the body of law throughout most of the counties, and it has changed somewhat in some counties, but the standard that was in place back then was 6 plants basically per person is what was defined as, and that was pretty, and a lot of the ordinances around the state still use the 6 plant definition. I mean, Mr. Hines modified it to 10 for his case. He said that's more than enough for one person. But when the Attorney General, announced that they weren't going to prosecute on a federal level anything over until it was 100 plants or more, that immediately created a vacuum that you might say, the business side of the marijuana growers, that they all of a sudden, interpreted the 6 plant rule, which is what everybody was kind of observing at that point, was now 99. I mean, it just literally filled that vacuum, and that's when a lot of these counties were having the kind of problem that we were listening to was taking place up here at Lake Forest, where they were filling up the yards and they were doing, 4 or 5 yards and they get 99 plants in each yard, and now you got 500 plants, and the cartels that were getting, harassed out in the public lands and the forests and stuff being shut down and so forth. So why mess with the booby traps and the federales? We'll just sit back and wait for these 99 plant per yard grows take place, and we'll just go in and harvest those and rip those people off. So I mean, the game really changed a lot in the last 18 months to 2 years from what that discussion was back in 2010 that led to our adoption of the 575 ordinance.
well, so if I may, Mr. Chairman, I know we've got some things to do. So in the conditions for cultivation, that section, which is A, B, C, and D, and E, which starts on page 4 towards the top and finishes about a third of the way down page 5, that can be what you want it to be, essentially, as long as it's reasonably related to the nuisance that you're intending to prevent. And there are different examples. Tehama's got some different standards than Sierra does. There are other counties, Butte and Shasta have some other standards in place as well, and I believe that they should be an expression of your values, essentially, exercised through your police power, and I can craft that in several different ways. Again, the purpose for today is to introduce to you a taste of the structure of what I think is a viable ordinance for the future. And again, I'm not married to or nor do I endorse necessarily or recommend to you adoption of those conditions of cultivation which are incorporated in the one that's in this draft. I think, actually, there may be some things that are in here that perhaps are inconsistent with what your direction was to me in December. I didn't even address that necessarily. again, the point today was to introduce to you a taste of the structure of it. What I will tell you is that where I am going to back up a little bit and say I support and will likely recommend, maybe with fewer changes, is everything after the conditions of cultivation.